That is not our choice, but of course, from my point of view, what I have been deprived of was the very important feedback from my students. So, which actually is a way of learning, not only you learning what I try to impart on you, knowledge, information, but also I learn how to teach you. But I hope now we have come a long way now, and to the moment when we are actually doing a revision. The revision obviously cannot be done unless you have done your preparation. Otherwise, this would not be a revision, right? But a rerun of the lectures, and we don't have that time. We don't have that time. And my purpose, therefore, is, well, and I have to be pragmatic, and my main purpose tonight actually is to hopefully help you to be more effective in your revision for the purpose of taking your examination. I think it's on June the 10th, right? Now that is the focus, that is the objective. What I'm going to do is to focus on the main points, which I believe will be useful for you when you do your general revision. And I will take questions in the course of the lecture. You don't have to wait until the end of it. So when we get to a certain point where you thought you needed elaboration, you needed clarification or explanation, do raise your hand and we'll deal with that. All right? So that's my introduction to this session tonight. Are there any questions from you? Right. So with the Hong Kong Basic Law, we are so lucky, and you are so lucky at this very moment doing a course on the Basic Law, because a lot of things are happening right in front of us, or right around us, and so on. And indeed, since 2019, right, a lot of people are getting more, are becoming more aware of the fact that there is such a law called the Basic Law of the Hong Kong Special Administrative Region. Right? And there have been a lot of discussion or a lot of concern about the relationship between the Hong Kong Special Administrative Region and the central authorities of the People's Republic of China. From a student's point of view, I don't know whether that actually raised a concern about what do we have to study. We only have a manual which was based on what the law was probably 2 years ago. And I didn't bring Mr. Danny Gigging's book, and that book was published some years back. Now, so as a student, what do we do? Do we have to know and learn what the amendments to Annexes 1 and 2 of the Basic Law, which brought into effect the improvements to the Hong Kong SAR electoral system. The simple answer, and I hope you will expect that, is a clear no. All right. So, but I hope for those who take this course not only for the purpose of passing the exam, I will find it today when you read what is being reported on this subject, you become more, if you like, competent in understanding what actually is happening. What was the 5-step approach or process, which under which the relevant standing committee's interpretation had required, now is out of the window and replaced by something else. Right? That, of course, is good for our general knowledge, but not for the exam. Right? So, so that is what I wanted to make clear. That for the purpose of this course and examination, you need do no more than sticking to what you have, i.e. the manual, and then the accompanying reference material, and of course you will. There are three books here. The third one is actually the revision manual. I don't know whether you have been given that. Have you been given that? Yes, that is very, very useful, right? But of course, it depends on individual approach. Some may wish to start with the revision manual and see what actually the exam normally covers. The normal sequence, of course, you get yourself really familiar with what is in the manual first, right? And the PPTs that are used over the course, right? That is not to replace what is already in the manual, but to supplement that, right? Okay, so let's start. First of all, is an assurance that you need not go beyond what is in the course manual. And secondly, a subject of this nature is so broad that, and for your level, we had already set out or selected the main topics which you expected to know, and they are put into 8 chapters. It will be difficult for me to say which is the more important chapter, right? But then you should have at least a general understanding of the entire the structure of the entire course. So these 2 slides is actually to help you to focus and to refresh your memory, and to give you the assurance. You only need to know these. The assessment, which I had explained before, is first of all, 25% of the final mark will come from your assignment scores. Your assignment is being marked at the moment. I still have not finished marking them, and you will be definitely be given the marked assignments. I hope before by mid 3rd or 4th week, 3rd week hopefully, in April. There is this 2-hour exam, which account for 75% of your final mark. This the format of exam is this. Section A, there will be 5 short questions. In law, normally you will characterize questions as essay type question or problem type question. For our course, we do not have problem type questions. We will not put factual scenarios to you for you to analyze or express your opinion. This is most of which is, or in fact not most, but all of these are generally can be categorized as essay type. But some are objective, some are subjective, i.e. some are very direct, asking you about what. And then, especially with the short questions, And then with the long questions, we got under section B, there are 2 long essays. Each carries, I think 20. Each carries, that's right, 40. Each carry 40 marks, and you need only answer 1. Now the long questions will require you, on the one hand, provide the necessary knowledge on the subject being asked, and then express your opinion, form certain judgment based on what you have presented. Very straightforward, no tricks at all. These are very straightforward questions. So 2 sessions. Section A, got 3 questions that you have to answer out of the 5, and each carries 20 marks. And then that's 60 marks, or 60%. And then for B section, 2 long questions, and you need only answer 1 each, and it carries 40 marks. 2-hour exam. Now this is where you must exercise great discipline when it comes to exam. I'm sure many of you would have a lot of experience in writing examinations, and for a subject like this, it's very demanding. 2 hours go past very, very quickly, so you must discipline yourself. Divide up the timing for each question. Once the time is up, move on to the next question. Right? Don't sort of stay with a question until you think you thought you had written everything, right? And don't affect your division of timing because you thought you might not have much to write in the last question or whichever. Don't give yourself such an excuse. Be very, very disciplined, because when we mark papers, the worst case scenario is when you find no answer to a question, then the marker, even if he or she wanted to give you some marks, there's nothing. So you've got to be 0. So please be kind to yourself. Don't deprive yourself of the opportunity of scoring. Right? Of course, you may think that, well, to answer what in effect 4 questions, it may not be easy, in the sense that many of you, or many of the students, will probably focus on 3 or 4 main topics. We've got 8 chapters. You say, okay, I'll focus my effort into 3 or 4, and then when you look at the questions, you didn't really. You found that your 4 topics did not cover enough questions for you to answer. But that might happen. If it did, you will have to be courageous and be bold to make sure that you write something down. Right? That you have to provide full reasoning. Authorities, decided cases, examples should be cited where appropriate. This is again where students who are new to doing law always worry. It's well, how much do I have to memorize? How many cases do I have to know? and when do I have to cite any of them? And when I cite them, how do I cite them? Do I just set out the name, and then following which, how much do I have to say? The revision manual will help you. There's a session on that. I would like to repeat that. And I believe you have been given a session on that as well. Just go back to the notes. The short answer is yes. As I said, as on the slide, you are expected to cite cases. You are expected to cite cases, especially when it comes to questions asking about human rights. Right? That is obviously a very important subject. But you can see the course manual. We spent at least 1.5 chapters on that, on how Article 39 operates, how the court, this is what you have done for the assignment. Definitely is an important subject, and a subject which requires you to know the cases. When you mention proportionality, you can't really have a complete answer unless you have hyphen in it. Yes, you cannot finish answering the question without putting in Leung Kwok Hong and the right Leung Kwok Hong case, right? So that is those are a must. Like when you're doing tort law and contract law, there are cases, the leading cases, you must know. So in our case, the must-know cases are not that many. Go to your manual. Go to your manual, and that's it. That's all that you need to know. Of course, for the more conscientious students, for the better students, we say, you may remember what is said in the most recent anti-mass law case. You may even, if it's relevant, cite the latest case on the interpretation of the national security law, if it is relevant. This is where Lai Jiying failed to appeal to the Court of Final Appeal. The government appealed to the Court of Final Appeal on the bail application, on the Court of First Instance granting of bail to Lai Jiying, right? So my last point, cases, yes, you have to know, but only those that we refer to, either in the manual and maybe during class. All right? And as far as how much about the case, two things. One is you have the ideal situation is to provide a line or two on the facts of the case, and then a must is the legal principle. The reason why you cite the case is to show that that is the case which established a certain principle, or which is illustrative of a certain principle. The Hyson case, for example, you will cite it only if you want to make reference to the 4-stage proportionality test, because that is the very case which established the fourth stage test, which is a balance between the societal benefit against the burden on the citizen, whose right is being infringed, right? So that is about the reference to cases. Okay, any questions on this or from this?
Do you have to remember all the cases in the manual, or just some of them are must-know cases?
It's very difficult actually the question is two parts, right? Do you have to remember all the cases or only part of it? Actually, it's more difficult to decide which part of it you have to remember. So I would suggest you remember all of them and cite them when appropriate. It will be, logically, it's more difficult. You say, oh, I only need to remember the 3 of these cases, right? Try, as a student, it's not difficult at all, right? Do write it out, and do make your own notes. Even I said, oh, this is Gongxiu is a very short case, right? Then it's at least it's a page or so, right? So you say, well, this is about the flag case, desecration case, freedom of expression, minimum impairment. Do some notes yourself, which will remind you of what the case is about. And then tell yourself, what's my contingency plan if I forget the name of the case? Don't worry. They said, oh, the flags case. This is about the prisoners' voting case. Don't be disheartened if you say, oh, yeah, I can't remember the Chan something. Don't worry. Even if you can't remember the full name, you say the Chan's case, which involved the voting rights of prisoners. That's it. No. That will be your fallback, your contingency plan. Got it? So don't worry about that. And I think the same technique could be used for your other law subjects. Right? But I found that it's always psychology. Sometimes it's even more difficult to decide. Oh, I only need to remember, for example, duty of care. You've done tort, right? So what would be the first case you will remember? Which is the leading case on duty of care? You've taken your exam already?
Donahue?
Hmm?
Donahue and Stevenson?
Donahue
And Stevenson?
Donahue against Stevenson.
Yeah.
Remember though, right? So what's the case about?
It's about the decomposing snail inside the bottle.
Yeah, the snail in the ginger beer bottle case.
Yeah.
Right? These, I learned Donahue and Stevenson when in my first year of law, right? And that was, I don't know, 40-something years ago. I still remember that, yeah? And we're still citing that in court, right? Do contract when you do Kalau against Catholic Football. Remember that case? Kalau against Catholic Football. What is that case about? Hmm? Sorry? Yeah, legal principle is unilateral offer. It could be an offer. And then acceptance by way of conduct. Yes? And, but what is it about? I can't remember.
The person that you won't get sick if you take the smoke out.
Yeah?
But then when the person got sick and sued the company.
Mm-hmm. Yeah, it's you have to show that you actually responded to the advertisement, did what it said one has to do, and then you can collect your reward if you contracted influences still, right? These things, believe me, once you make some effort to learn that, you remember that for life. You won't forget it, right? These are, well, I always say this to first year students, don't worry. And once you make your effort to learn it, it's going to be in your blood, right? So don't worry. Or rather, you have to make some effort to make sure that it's in. Like the vaccines, you have to go and take the jab before you can tell yourself that you don't have to worry about COVID, right? Okay, so let me move on. Article 31. Why is Article 31 of the PRC Constitution so important? Why is that important?
The ground of the basic law.
The ground of the basic law.
The basis.
The basis of the basic law. The basis of the basic law. Agree? Without Article 31 of the PRC Constitution, there will be no Hong Kong basic law. Agree with that? I think we should all agree. But why? Now, the reasoning. Why? Because your examiner is always looking for your reasoning. It's easy to say what you just said, but why?
Declarations. It specifies is the implementation of Joint Declaration.
When was Article 31? When did Article 31 come into existence?
Maybe 1982.
So when was the Joint Declaration?
1983 or I think.
That's after Article 31, wasn't it? So Article 31 was not for implementing the JD, unless NPC has a crystal ball and knew that there was going to be this joint declaration. So they are related. How are they related? Now this is a bit vague, you know. They are related. We are all related, but how? We are related because I'm teacher of a class in which you are a student. These are the wording of the provision. The state may establish SARs when necessary. The systems to be instituted in SARs shall be prescribed by law enacted by MPC in light of specific condition. It's very general. It didn't mention joint declarations, but this was 1982 PRC Constitution. It was all in the context, don't forget, initially for the unification of Taiwan, right? And of course, that became Deng Xiaoping's idea, the basis that could be extended to Hong Kong and Macau, and it did, right? And it did. And this is, of course, when the JD, when the two countries were negotiating, China was able to say, look, we've got this. And we will, they say, in the joint declaration, they make a declaration that they will reflect the basic policy on the future of Hong Kong in a basic law to be passed by MPC. And this was considered as acceptable because there was Article 31, right? So when we talk about just looking back at the sequence, you will know the relationship. And so Article 31, an important one that we all should remember. These are slides that I had shown you in class. I'm not going to read them again, but this is just to bring back the sequence of events. And I mentioned about the basic policies. Do go back to the JD and remind yourselves about what were those basic policies. We had gone through the drafting history, and of course the drafting history itself are but the sequence of events. What is important for us as students of the basic law is about what were discussed and recorded in the course of the drafting, and all that are useful materials that the courts in Hong Kong would be prepared to look at in order to examine and ascertain the intention behind certain provisions of the basic law. Very contentious question, a question that attracts a lot of political exchanges in recent months when UK government either on an ad hoc basis or in the half-yearly report on Hong Kong had been and still is challenging or accusing PRC of acting in breach of the Joint Declaration. PRC at the diplomatic level fired back and said, JD is JD. You no longer have a basis of intervening the internal affairs of PRC, including how HKSAR should be governed, and which is being governed or in accordance with the Basic Law. So those are political stance. As a student of the law, we have to look at the matter, and especially a student of the common law, those statements, whether are obviously relevant, but more relevant to us is what the courts in Hong Kong, how do they treat the Joint Declaration. So when you are asked the question, is the Joint Declaration still important? Of course, historically, that must be important. Without the Joint Declarations, there will be no basic law. But the Joint Declaration itself doesn't mention important issues such as universal suffrage. That is something which came later. And in 2017, the Foreign Ministry has said that the JD is an historical document that no longer has any realistic meaning. But in the course of Hong Kong, JD is still something can be relied on in appropriate cases, in interpreting, if useful, in the interpretation of basic law or Hong Kong provisions, basic law mainly. There are a couple of cases which, as a matter of legal principle, we have to make clear. Joint Declaration can be categorized as an international agreement or treaty or convention, although it's called Joint Declaration. Obviously, it's an undertaking entered into between two independent states. And indeed, the instrument, the document itself, has been deposited in the UN, in the depository of treaties. So by that, you could sort of quite accurately describe that as an international agreement. And under the common law, the principle is international agreements do not have the effect of law within the jurisdiction unless the content of that agreement has been domesticated, has been translated into local legislation. So as a matter of strict law, JD, the Joint Declaration, does not have the force of law in Hong Kong. The authority that we normally cite is the case of Tang Ping Hoi. But the name is not important actually, because it is what we call a trite principle, a trite law. Trite is fundamental in common law. It's so fundamental in common law. But the courts have said, because of the link with the Hong Kong Basic Law, the courts have said in the past that Joint Declaration can be used to understand the purpose and the context of the provisions of Hong Kong Basic Law. And that this was said in the cases of Ngarling and the other case of Gurunkesh Bahadur against the Director of Immigration. All the two cases concern the right of abode and the status of a person, whether he or she could be treated as a permanent resident, and how Article 24 of the Hong Kong Basic Law should be properly interpreted. So in short, if you were asked about whether Hong Kong Joint Declaration is important or how, what status does it have, this will be the approach. The three dimensions to the Hong Kong Basic Law. This is a little bit this is not real strict law, but it's an approach adopted by the case and used by the case of David Ma Wei Kun, which was a very early, constitutional case, 1997, 98. That case was incidentally is a criminal case, but the judge took the opportunity to explain what the Hong Kong Basic Law is within the Hong Kong legal system in the new constitutional order. And they try to place it, or try to describe that from three perspectives, and gave the Hong Kong Basic Law the three dimensions: the international dimension, the domestic dimension, and the constitutional dimension. These, in a way, is one way of ramping home and the message that the Hong Kong Basic Law is a very unique piece of law made by the NPC. It's unique because there's no law prior to this that bear these characteristics, i.e., which you can look at it from the international perspective, or at the same time the PRC perspective, and lastly the Hong Kong perspective. What are these about? International dimension, and it says that this is found in the preamble, which tells you that the purpose of the Hong Kong Basic Law is to implement basic policies of PRC regarding Hong Kong. And these basic policies were originally stated in the Joint Declaration, which is an international treaty registered with the UN. So in the case of Ma Wei Kun, the court held that international dimension there is this international dimension because it implements an international treaty. Right? Now, we are not students of international law. You may continue to ask and ask why. So with this dimension, does it bring with it certain rights and obligations on the part of the PRC? Now that would be a very good question, but it will be outside of our remit. It will be something for international law, and which is something you can be assured that UK, the position taken by UK and PRC will be different, and the respective positions are different today, and it will remain the case. And then this is not something unusual, and you have already seen many of these similar situations where different countries may take different stands, or different view on what the international law is, or what the respective obligations or rights and obligations in international law. And that is something typical of the international law, i.e. you don't really know. And because it contains a body of rules and norms and customs, which is subject to different countries' own interpretation. Right? And that makes the study of international that more fun. Right, and we need not concern about those. except to know that there is this international dimension, and also there is such a dimension because of the JD. Domestically, well, the Basic Law is a piece of national law, PRC national law made by the NPC, the National People's Congress. So when we say domestic dimension, we are actually talking about the PRC. At this point, without digressing too much, it's just to remind ourselves that NPC, National People's Congress, is the supreme organ of power under the PRC Constitution. It is not simply a legislature like LegCo. It can do a lot more than making law. Indeed, in the Chinese legal system, it is not only laws that it pass which has legal effect or the force of law. Now you know, and you have learned, well, now you know, actually decisions made by the NPC has the force of law. The most recent decisions that the NPC had made, which concerned Hong Kong, will be the two decisions, one made in May last year, which concerned the national security law. It made a decision that the Standing Committee ought to make a law for it to apply in Hong Kong for safeguarding national security. And the second one would be the decision made in March that the Standing Committee has to amend Annexes 1 and 2 of the Basic Law, trying to improve with a view to improving the electoral system in Hong Kong SAR. And that decision was made last week, no, it was early this week, and it is being implemented, and then the local law, Hong Kong electoral law, is being amended at the moment. Oh, I beg your pardon. Amendments to the local law are being drafted, and it will be presented shortly to LegCo, the Legislative Council, with a view of their passage by end of May this year, so that the 3 elections can take place in the order of firstly the subsector election for the election committee, and then followed by Legislative Council election in December, and then March next year, chief executive election, right? So that, just digressing a little bit, but coming back, this is PRC dimension of the Basic Law. And indeed, I brought in NPC, and here, don't forget, NPC has, being the supreme organ of power, actually governs Hong Kong, it can govern Hong Kong not only through the Basic Law, but other means as well. But the Basic Law does set out rules of China as well as Hong Kong SAR. Right? Any questions from here? Constitution dimension, Hong Kong. Now this is one we have to look at very, very carefully, right? Especially on terminology, because the terminology, I mentioned this during class, the fact that Hong Kong Basic Law is a piece of national law, PRC, which applies throughout PRC, but as far as Hong Kong is concerned, no law passed in Hong Kong legislature can contravene the Basic Law under Article 11 of the Basic Law. So in that sense, it has a superior, it has a status superior to other laws in Hong Kong. And for that reason, it could be described as having a constitutional status. Constitutional status normally we normally mean is super law. It's a piece of super law that no other law can contravene. That fits in and therefore it fits in this constitutional dimension description. But don't forget, we never say, and we should never say, Hong Kong Basic Law is the Constitution of Hong Kong, SAR. Why? Just for a very simple reason. Why we cannot describe that as the Constitution of Hong Kong SAR? Not in the context of dimension, but simply say, because this dimension is the constitutional dimension, and I said, that's fine, but we do not therefore say Hong Kong Basic Law is the Constitution of Hong Kong SAR. And my question is why? Why we do not say that, or we cannot say that? Yes, Hong Kong is not a state, not a country, right? So we say constitutional, not constitution. Constitutional, right? In Cantonese, it will be 憲制性. It's not 憲法. It's not constitution, right? It's an adjectival description of the nature of the document, right? Having said that, unless you are a purist, we do find people, including judges, describing the Hong Kong Basic Law as the mini constitution. So do be aware of that. Be aware of that, and you can't really say it's wrong. To be honest, just a matter of linguistic language. A constitution is constitution is a constitution. You don't really have mini constitution, right? So when you describe it as mini constitution, it should already bring out the message that it is not a constitution, right? But some may find it offensive that even such an expression may be disrespectful of the central authorities. That you may think well, that's politics, right? That's politics more than anything else. But as a law student, as a student of the law, of course we should be aware of that. We want to be accurate. We want to be precise. So any questions arising from these dimensions? If you wanted to cite a case, that would be just one case, Ma Wei Kun, David Ma. Next topic I want to touch on is general application of national laws in Hong Kong. One country, two systems, high degree of autonomy. Hong Kong is authorized to exercise legislative power, administrative power, and judicial power with the power of final adjudication. So in terms of applicable law, in order to give effect to the one country, two systems, the basic law has authorized Hong Kong to make its own law, provided that it cannot contravene the basic law. And any law made by the Hong Kong legislature has to be reported to the Standing Committee of the National People's Congress under Article 17. But in order to reflect the fact that Hong Kong is only an SAR within China, there are national laws which can be applied in Hong Kong, but through a mechanism. The mechanism devised by Article 18, and which provides that only national laws set out in Annex 3 applies. And this they apply either by way of local enactment or by way of promulgation by the chief executive. And there is one further limitation, there's one further condition, or that these laws should be those that concern national security, national defense, and foreign affairs. Not everything. And if such law was thought should be applied to Hong Kong, there should be consultation with the Hong Kong Basic Law Committee beforehand, and you will see that the way we present this topic is to say the last step still lies with Hong Kong, either by way of enactment or by way of CE promulgation. The latest examples that you can see, what are the latest examples about the application of national law in Hong Kong? The latest examples. National security law, yes, that's right, the NSL, right? And that is by way of, the law was made by which organ, which institution made that law? NPC? NPC government? No? Well, no. Chinese government. Which is the Chinese government? Mainland. The name? Well, Standing Committee of NPC. Now.
What's the difference between NPC and NPC-SC?
Very good question. The question is, what is the difference between NPC and NPC-SC? NPC full name is National People's Congress. It is the supreme organ of power. It comprises delegates or deputies, 人大代表 of 2,000 something in number, who are elected under the PRC electoral law, and they are representative of the various provinces, the autonomous regions, and the SARs. For Hong Kong, there are 36 such delegates, such representatives. These are 人大代表, right? And that is the National People's Congress system that applies in PRC. It is a system which is entirely different from that being practiced in other countries. UK is a parliamentary system. US is a congressional system. French is half and half. Each country decide its own system. You may describe this as a communist system, but it isn't. This is an NPC system. The NPC meets once a year, normally in March, for about 10 days or 2 weeks, depending how long the agenda is. Last year, NPC did not hold its annual meeting in March because of the pandemic. Eventually, it held its meeting in May. One meeting, 1 year. The supreme organ of power, comprising 2,000, nearly 3,000 delegates. How can it govern PRC only by meeting once a year? So it can't. It needs to have a standing body, i.e. it is always there, and that is the Standing Committee of National People's Congress. It comprises normally about 150 to 170 something delegates. These members they, if you like, they are in real control. They are those who are in real control because they meet, on average, they meet once every 2 months, sometimes more regularly than that. And normally they meet in the even months, February, April, June, and so on, normally, right? But as we all know, it met in March this year because, and on one of the agenda was to pass the amendment to the annexes of the Basic Law. What's the difference? NPC, Supreme Organ of Power, it makes all the basic laws. The basic law, the word basic is spelled with a small b, 基本法律. And other laws, less important laws, can be made by standing committee or as authorized by the NPC. So that's how the division of work, division of work, right? Government. So what is government? What is government? Is NPC the government? Is NPC standing committee the government? No. So which is the government? The State Council. The State Council. 有人皺眉頭，咩嚟嘅？國務院 ，OK， State Council， you know 普通話 Cantonese， 麻麻地國務院嚇，國 means the state， 務 means affairs of the state， the 院 is the institution， 國務院 ，rarely we hear that right， 國務院。Very often, at the same time, we hear CPG. What's CPG? China Republic government doesn't really fit. CPG is Central People's Government. 中央人民政府 there's a government. That's the State Council. Which is which? Are they the same? Are they two? Are we referring to two bodies? Not really. Very confusing, huh? Very confusing. Because there's another expression. Go to our basic law, you see reference to central authorities. 中央. What is 中央? 中央, huh? Central authorities, what is that? Now, this is a revision class. Let me get straight to the point. Right. Quốc務院 is the core of the government. This is where the State Council, right, comprises the 國務委員. These are the Li Keqiang, these are the Wang Ai, these are the all these famous names these days, going out to meet this and meet that, right? They are the state councillors. They decide a lot of things, including making law. They are also vested with the power to make law, although their power is subsidiary to that of the standing committee, right? And so how is it relevant to us as the SAR? If you want to look at an organization chart. So, which is above us? Which body is above Hong Kong? Within the PRC system, governmental system, what is above SAR is CBG. When you read Article 2, let's look at Article 2. Now, Article 2 tells us it's the MPC which authorizes SAR. MPC which authorizes SAR. And then Article 12. Article 12. Hong Kong SAR shall be a local administrative region of PRC, which shall enjoy a high degree of autonomy and come directly under the CPG, Central People's Government. Got it? So this is how it's related to us. And you will see that it is so, it affects us so directly that under Article 45, I believe, yeah, under the 45, under Article 45, it says, the CE of Hong Kong SAR shall be selected by election or through consultation held locally and be appointed by the CPG. So you see that after Carrie Lam, after C.Y. Leung, after Donald Chang and Dong Chihua, after they're being elected in Hong Kong, they have to travel to Beijing and be appointed by and receive an appointment letter or certificate from the Prime Minister, the Premier, or Premier. This is what? This tells you that in law, the Carrie Lam and the C.Y. Leung cannot become the CE, even they had successfully elected by Hong Kong people, because they need to be appointed. So in theory, the Central People's Government can refuse to appoint, right? And then when you look at Article 73.9, we talk about this, and this is important. The relationship between the Legislative Council and the CE. The Legislative Council can pass a motion to impeach the Chief Executive by 2/3 majority. Now, Donald Trump been impeached, been under a motion of impeachment 2 times, although they did not get passed by Senate. In Hong Kong, we also have the power to impeach. Yes? No. Hong Kong has the power to pass a motion to impeach. And that motion, as to how that motion should be dealt with, is a matter for the CPG. You look at Article 73.9. There's a lot there, but you need only go to the last two lines, 3 lines. The Council may pass a motion of impeachment by 2/3 majority and report it to CPG for decision. So the CPG can decide whatever. Of course, the decision can be doing nothing, or snap on the knuckle, or dismiss him under Chinese law, because the appointer obviously has the power to appoint and a power to dismiss. So back to here, I think although this is on application of national law in Hong Kong, I think it's also an appropriate point to highlight the relationship between central authorities, CPG, MPC, MPCSC, and so on with Hong Kong SAR. In total, we may describe that as central authorities. The concept, the central authorities may include all that. It's a bit, if you like, it seemed to be a bit vague to us. But central authority is a very clear concept in China. And to some extent, and in certain contexts, it may also include the Politburo of the Chinese Communist Party, right? 政治局. So that is something which maybe not as well known, right? And of course, even within PRC legal system, the relationship between the Chinese Communist Party and the NPC is a subject which is always subject to certain tension, 有啲拉力啊，政府同埋黨嘅關係啊，咁呢個我哋not for us to discuss today, but then it's something which is again does have a bearing, a very important bearing in how PRC governs the country, including Hong Kong, right? Because under the PRC constitution, the Chinese Communist Party does occupy a very important position, doesn't it? What important position does the Chinese Communist Party occupy in PRC constitution? No? Well, under the Chinese constitution, the CPD, this Chinese Communist Party, CCP occupies a leading position. It is under the leadership of the Chinese Communist Party, in conjunction with other political parties, other liberal and other democratic political parties. So in strict legal terms, when you say China is being run by an autocrat or autocratically, China doesn't admit that, because China says no, we are operating under a collaboration among parties, and the fundamental principle is the ideology is people's democratic dictatorship. But we shall just treat this as something there that for you to delve into later if you're really interested, right? Okay, so but mind you, one country, two systems. You do, I think, in order to understand Hong Kong basic law accurately, you do have to know, what is in the one country, which concerns the Hong Kong SAR directly, and of course indirectly as well. Three restrictions. This is where I said, well, for the national law to apply, there are certain conditions. And you may describe these as restrictions or simply conditions as a matter of law. It has to be, these national laws have to be listed. Oh, by the way, I mentioned national security law as an example. There's also another one which, or national security law applies to Hong Kong by way of promulgation. But there's another one which applies but not by way of promulgation, but by way of local enactment. What was it? Local enactment. A law was passed in Hong Kong Legislative Council to give effect to a piece of national law listed on Annex 3 of the Basic Law. And that is Annex 1 and 2 doesn't need promulgation or a local ordinance to give effect. It is already law, because the standing committee was authorized by the NBC to make such amendment. Right? National flag. Yes and no, because I was asking for the latest one. Yes, exactly. National anthem law. National anthem law, right? I knew you all know. Yeah, so national anthem law. That had turned out to be one of the passage of that law turned out to be one of the objections that protester had expressed, wasn't it, last year, 2019. That's when, because certain legislators, you remember, they took measure to delay or to prevent the passage of that law, and some of these legislators are being, I don't know whether they've been charged or not. They've been arrested, some of them, for the conduct, for the behavior in the delaying the passage of law in Legislative Council. So these three restrictions, in order for a piece of national law to apply, first of all, it has to be listed in Annex 3. Secondly, it has to be promulgated or enacted by Legislature, and they can only come within Annex 3 if they concern defense, foreign affairs, or other matters outside Hong Kong autonomy. So this slide is we actually covered this already. State of emergency. This became a point of focus in 2019 when the CE, when Carrie Lam made the anti-mask law, and there was at that time suggestion that she could actually invoke the basic law and declare emergency, or seek to declare emergency. But Carrie Lam, the CE, make it the point that it wasn't emergency. It was what was? Oh, I just forgot about that. It was not. It will come back to me. It's under she invoked the emergency regulation ordinance, and under which there are two situations under which she could make subsidiary legislation. Such legislation could actually repeal or amend existing ordinances, as if such power normally could only be exercised by the legislature itself. But the CE was given tremendous power under the Emergency Regulation Ordinance, and there were 24 legislators who took government to court, and arguing that the Emergency Regulations Ordinance was in contravention with the Basic Law and should be, and all the subsidiary legislation made under it should be declared invalid. The anti-mask law, therefore, should be invalid. The Court of Final Appeal did not agree with that argument, and held that the subsidiary legislation made, the anti-mask law made, was constitutionally valid. And furthermore, there was also complaint against the anti-mask law, the regulation, that they were in breach of the human rights provision under Article 39 of the Basic Law, and also under Hong Kong Bill of Rights Ordinance. is a bit complicated in the sense that the case went through the 3 tiers of court. In the CFI, only one provision was found to meet the human rights test, and the Court of Appeal did not agree entirely with the Court of First Instance and maintained 2 of the provisions. And then when they went to Court of Final Appeal basically preserved all her provisions, did not find them as having infringed any of the human rights protections provision. But there was one which government accepted and did not appeal, and that was the provision, which is Section 5 of the regulation, which empowers a police to order any person at a public place to remove a face mask, and any disobedience with that demand constitute an offense unless there are reasonable grounds. Right? That one was found to be too much, to have breached the proportionality test, and therefore could not stand by the Court of First Instance. Government did not appeal, accepted that. The main reason was, even without that provision, government or police officer already possessed such power under immigration ordinance and under public order ordinance. Under immigration ordinance, you remember or you know, police has the power to demand us, anybody in a public place, to produce ID card, right? In order to make sure that you are actually producing the ID card, I think it's reasonable that for the police to say, let me see your face. So if you were wearing a mask, to let you see your face must include removing your mask. So if you did not comply with that demand, that will be an offense under obstructing the police officer in the due execution of duty. So that is about the anti-mask law, and I brought this in because of the Article 18.4, the emergency situation, where actually CPG has the power to apply directly national laws in Hong Kong, and that will be able to bypass the Article 18.2 and 3 requirements. At the same time, if that should happen, there will be the Hong Kong garrison, that is the People's Liberation Army, PLA, will also be empowered to exercise its powers in Hong Kong according to law. So that's 18.4. I'll skip that very quickly. So before I move on, any questions?
No review. People appeal fine against the government. Is it a judicial review or constitutional review?
Which case?
Anti-mask law.
Okay. The anti-mask law is a judicial review case. Now, let's get the concept right. Judicial review is the term we use to describe the proceeding. You say, oh, what sort of procedure is it? Oh, this is judicial review. Under the judicial review procedure, the court can do various things. And the conventional thing that a court would do is to examine the lawfulness of a certain government decision or act or policy based on the three grounds: legality, the irrationality, and the procedural propriety. That's the standard JR, standard judicial review. If the review involves a challenge that a certain piece of legislation, including subsidiary legislation, contravenes the basic law, and therefore, in accordance with Article 11 of the basic law, cannot be valid. That is what we say constitutional review. Constitutional review, right? And in constitutional review, if it should involve a complaint that the certain law was in contravention with Article 39. Article 39 is an article which gives effect to ICCPR and other international conventions through Hong Kong law, and this is your assignment, right? Your assignment. Now that involves what we call constitutional review. That's constitutional review. Right? And in such reviews, when you go home tonight and when you read about the decision on the 8/11, on August 11 case, this decision made today, where people were convicted of unlawful assembly, including Martin Lim, Margaret Ng, and others, Jimmy Lai, and so on. There was a challenge of unconstitutionality on the conduct of police officer on the ground. Now, that is something that we did not cover in our course. That is operational constitutional review. This is about what we have been doing is the constitutional review of law. Actually, that can also cover actions. So the complaint that the defendants had was the police officer on the day when they dealt with the protester and marchers at Victoria Park were acting in contravention with the basic law. Acting in contravention, in particular, in contravention with the human right protection and the right of freedom of assembly, freedom of possession, as protected by the basic law. So the court was invited, or the court had to examine each of the operational decisions made, including the decision to withdraw 80-something police officers from Victoria Park. So that is another kind of review. It's also judicial review. And indeed, the same or similar concept. This is a very broad jurisdiction, very broad power of the court in our common law system. In the Legislative Council oath case, remember those cases? Legislative Council oath case. No? The Leung Zhonghang. The Yao Leijing. Huh? Remember that? Yes. The court also did a full merit review. The court actually examined the video clipping of what Mr. Leung, what Ms. Yao and others in the serious cases, what they actually did, and form a view as to what, whether they were taking the oath in compliance with the Oath and Declarations Ordinance and the Article 104 of the Basic Law. That is also a kind of judicial review. So, sounds a bit complicated, but the message is, in common law, the courts, they do have pretty wide powers. And it really depends on how you frame your case, how you articulate your case, and invite the court to exercise its jurisdiction. But mind you, whatever they do, the remedies they can give may not be the remedies that you need, that you want. Because in JR, what you can only get are certiorari, mandamus, and prohibition, and in some cases, damages. So it doesn't say, it only examines the lawfulness of certain action or conduct or law. Lawfulness, the rule of law. It is a mechanism that the court used to safeguard our rule of law. That's the bottom of it. It is not a typical conventional litigation asking the court to decide who's right, who's wrong. Not that. And this is something very unique or very important in the common law system, something that the central authorities and scholars on the mainland also found find so different from that on the mainland, right? There's the courts on the mainland simply do not have such power. Right? Okay. Now I think let's take a break, 10 minutes, right? And if you have